All right, this is case number 25 CR 51, State of Ohio versus Timothy B. Campbell. Appearing on behalf of the State of Ohio is Assistant Prosecuting Attorney King. Appearing on behalf of the defendants, Attorney James Bolger of Chillicothe, Ohio. And are you Timothy B. Campbell?
Yes, Your Honor.
Mr. Campbell was indicted for felonious assault, a second-degree felony, on May the 6th. This is before the court for arraignment. Mr. King, has the alleged victim of the offense been notified of the time, place, and purpose of this hearing, the right to be heard?
Yes, he has, Your Honor. He's elected not to attend the hearing this morning.
All right. Mr. Bolger, do you wish to have the indictment read?
No, Your Honor. We waive the reading of the indictment and acknowledge receipt of the service of the summons well in advance of 24 hours. You can waive any recitation of rights associated with the plea and is prepared to enter a plea of not guilty.
All right, thank you. The file indicates there was a real estate bond posted.
I believe it was a surety bond, Your Honor, $30,000.
Okay. And well, originally I saw an order for $30,000, then I saw, or $100, and then I saw another one that said $30.
It was changed at preliminary hearing.
Is it $30,000?
Yes.
We don't have that. I'm looking here to see if I can find it. The initial appearance on the 19th of February was set at $100,000 cash, surety, or real estate. Then, let's see.
Your Honor, I have documentation with me concerning the surety bond. I don't know if it's been transmitted from the county court.
Okay, I have the entry, February 24th, $30,000. Yes, if you could give that to the bailiff, and we'll take it down and have them call to see where the original is. All right. So bond will be continued amount of $30,000 plus your OR, Mr. Campbell, which is your promise to appear. And if you fail to appear, you could be prosecuted for an additional felony and a convicted sentence, no matter what happens in this case. Well, I was trying to get Ben. Ben, would you take that bond downstairs and ask the clerk? Yeah, oh, there. Ask them to find out. Ask them if they have the original, or if not, call county court and see if it's there, because I don't see it in here. You'll also be required to pay a deposit of $116 within 30 days as to cover certain statutorily required fees. If you you'll be under pretrial supervision of the probation department at 117 East Main Street. So you'll report there immediately after court. And you know where this is located? Okay. You'll be required to report to them once a week for 4 weeks, and after that, as they determine. Undergo random drug testing they may order. Provide phone numbers for home, cell, employer. Have no contact with the alleged victim. Also may not be on the VFW premises, Greenfield VFW premises. If recommended by probation, you can be evaluated for substance abuse or mental health issues. If they recommend any treatment, you'll enroll in and follow that during the pendency of this action. Is your address 1191 Cliff Run Road?
Correct, Your Honor.
All right. You'll be under house arrest then at that location as a condition of your bond, unless you're working, or if you're going to and from work, going to and from any kind of medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case, attend any kind of educational programming, schooling, job training, etc., and also church services. Other than that, you have to be there at all times. If you fail to comply, then that bond could be revoked. You could be held until further order of court. All right. Is there anything further, counsel?
No, Your Honor.
No, dates.
Oh, I didn't set any dates.
Yeah. Sorry.
Thank you. Wait a minute, Mr. Holder. I need to get the dates here. Let's see. June the 25th is our next pretrial day. Be available that day in the afternoon.
Yes, I am.
All right. June the 25th at 2:00 p.m. That could be done by Zoom, Mr. Bolger, if you want to do it that way. You just either need to have your client at your place, or he can go from his place if he has a phone, or if not, he can go to the probation department. Final pretrial then July 16th.
15 or 16?
16th at 2 o'clock p.m. And then the trial would be set for August 11 at 8 a.m. All right, so Mr. Campbell, you'll need to sign your assignment notice here with the bailiff, then go down to the clerk's office to sign your OR bond for this court, and also we need to confirm your bond, where your original bond is. If not, we'll just substitute a copy of that until we can locate it. You can then go down to probation to report for your pretrial supervision. All right, thank you.
Yes, sir.
All right, Francis Horny. Let's have a seat. All right, case number 25CR71. Ben will need to take that downstairs, but okay. State of Ohio versus Francis E. Horny. And you're Francis E. Horny?
Yes.
All right, Ms. Horny, you were indicted by the grand jury on May the 6th on a charge of aggravated possession of methamphetamine. Alleges that on or about May 30 of last year in this county, you knowingly obtained, possessed, or used methamphetamine in an amount that equals or exceeds bulk amount of less than 5 times bulk amount. That is a third-degree felony that carries a possible prison term if convicted of between 9 and 36 months and a fine of $10,000. Now, you are entitled to have an attorney to represent you. And if you do not have the money to hire one, the court will appoint one for you. I see you have filled out a financial disclosure form here. Is everything on that form correct?
Yes.
When's the last time you worked?
I haven't worked in years.
I'm sorry?
I haven't worked in years.
Okay, why not?
I have scoliosis and COPD.
Are you on disability?
Yeah.
Okay. Well, you have on your form you have checked under the TANF. Are you on SSI?
Yes.
Okay, so you just checked in the wrong spot then, okay. It's understandable the way the form looks. Okay. So that's what your 974 is?
Yes.
Okay. All right, the court then will find that you are entitled to appointed counsel. Is this the first time you've been in court on this case?
Yes.
All right, the court will appoint attorney Jacob Wagner of Hillsborough, Ohio, to represent you. And in the absence of counsel, the court will enter a plea of not guilty on your behalf. We will set your first pretrial for June the 4th at 2:15 p.m. Now, do you have a cell phone or computer that you can do video conferencing on?
Yes.
All right. So if you give that information, your email address and phone number to the bailiff, we can set that up by Zoom. Since you're at Bainbridge, you won't have to drive up here for that. So that'll be at 2:15 p.m. Your final pretrial will be July the 2nd at 2:15 p.m. Trial date will be in person, of course. If there is a trial, that'll be set for July 21 at 8 o'clock a.m. Since you were summoned, your bond will be an OR only. That is your promise to appear. If you fail to appear, then you could be prosecuted for an additional felony, convicted, sentenced on that no matter what happens in this case. You'll be required to pay a deposit of $171 in 30 days to cover statutorily required fees. You'll be under pretrial supervision of the probation department at 117 East Main Street. You report to them as soon as we're done here. You'll be required to report to them once a week for 4 weeks, and then after that, as they determine, undergo random drug testing they may order, provide phone numbers for home and employer if you become employed. You'll also be under house arrest at that address, at your home address there at Pumpkin Ridge Road. Is that 3614?
Yes.
All right, 3614 Pumpkin Ridge Road, Bainbridge. I'm sorry, West Union, which means that you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case. You can also attend any kind of educational programming, job training, classes of any sort, GED, college, etc., and church services. Other than that, you have to be there at all times. I don't recall if I said it or not, but you're also, if recommended by probation, to be evaluated for substance abuse or mental health issues, and if any treatment is recommended by the evaluator, you're to enroll in and follow that during dependency of this action. All right. So you're going to, were you fingerprinted and photographed out at the sheriff's office?
Yes.
All right. So you'll need to sign your appearance notice here. It gives you your dates and times of your hearings, and give the bailiff your email and phone number. If those change, you need to notify us so that we can send you the notification. If you don't get it, you have to come in person. And then you're going to go downstairs to sign your OR bond and make payment arrangements on your deposit, and then go to the probation department. You have any questions?
Yeah, I'm in treatment. Can I go back and forth to that?
Oh, absolutely. And that's part of medical. Yeah, absolutely. Go to treatment.
Okay.
All right. Elena Marie Barbrey. Okay, thank you. Case number 25CR65, State of Ohio versus, is it Elaine or Alana?
Elena.
Elena
Yeah.
M. Barker. All right, Ms. Barbrey, you were indicted by the grand jury on the 6th of May on a single count of aggravated possession of methamphetamine. It alleges that on or about March 29 of 2025 in this county, you knowingly obtained, possessed, or used methamphetamine. It's a violation of convicted of section 2925.11 of the Ohio Revised Code, a 5th-degree felony, which, if convicted, carries a possible term of incarceration of between 6 and 12 months, fine of $2,500. Now, you're entitled to have an attorney to represent you, and if you do not have the money to hire one, the court will appoint one for you. I see you have filled out a financial disclosure form. Is everything on this form correct?
Yes.
When was the last time you employed?
Yeah, probably about 4 months ago.
All right. And you don't list anybody that you're living with, and you list everything as zero, so I assume you're living with somebody who's taking care of you.
Well, my mom is staying with me right at the moment, but she's not going to be there that long.
All right.
But she is paying my bills right now, so I find
So
a
at the
job.
Mirabeau Street address, is that your place or your mom's
Yes,
place?
that's my place.
And anybody else live there?
No.
All right.
Well, that's my mom
Other
right there.
than temporarily, yeah. Okay. All right. All right. Then the court will find that you are entitled to appointed counsel. I'll appoint attorney Sarah Barber of Hillsborough to represent you. And in the absence of counsel, I'll enter a not guilty plea on your behalf. Your first pretrial will be set for June the 4th at 2:15 p.m. And you have an email and a computer. You can do video conferencing.
Yep.
All right. Give the bailiff your email address and your phone number, and we can do that by Zoom since you're in Greenfield. Final pretrial will be June the 25th at 2:15 p.m. And trial date will be set for July 10th at 8 a.m. You'll be released on your own recognizance, which is your promise to appear. If you fail to appear, you could be prosecuted for an additional felony, and if convicted, sentenced on that no matter what happens in this case. You'll also be required to pay a deposit of $171 within 30 days to ensure the payment of certain statutorily required fees. You'll be under supervision of the probation department at 117 East Main Street. You know where that's located? Yeah. Right, you report to them immediately after court. You're required to report to them once a week for 4 weeks, and after that, as they determine. They do also have reporting in Greenfield. So you tell them you're in Greenfield, and they should be able to work that out instead of you having to come over here for at least your first pretrial. Okay. Now, you'll report to them once a week for 4 weeks, and after that, as they determine. Undergo random drug testing in my order. Provide phone numbers for home, cell, and employer. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. Any treatments indicated, you'll enroll in and follow that during the period of this action. You'll also be under house arrest at your residence at 245 Mirabeau. You have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments from attorney, probation officer in this or any other case, you attend any kind of job training, schooling, church services, and also take care of personal business matters, which means like going to the bank or shopping or something like that for groceries. But other than that, you have to be there at all times. You'll have to notify the probation department when you're leaving and when you'll be back and where you're going. You have to go to and directly to and from those locations. Otherwise, you could be found to be in violation of your conditions of your bond and be held until further order of the court. Were you fingerprinted and booked at the sheriff's office? All right. So you're going to sign your assignment notice here. It gives you your dates and times. Give me your phone number and email. And make sure to keep that up to date with your attorney and with the probation and us. Then you're going to go downstairs, sign your OR bond, make payment arrangements on your deposit, then go down to the probation department for pretrial supervision.
Okay.
Have any questions?
Nope.
All right, thank you.
Thank you.
Dan, what was the dates I put on? State of Ohio versus Donnie Jenkins Jr., case number 25 CR 74. This is an arraignment. Mr. Jenkins was indicted by the grand jury on May the 6th. He was served a summons on May the 14th, which directed him to appear for arraignment before the court at 8:30 a.m. It's now 8:55 a.m., and he's the last case on the arraignment docket, and he is not present. So the court will order a capias to issue for his arrest. All right, case number 25 CR 58, State of Ohio versus Matthew O. Jones. And you are Matthew O. Jones appearing there from the jail?
Yes, sir.
All right, this is a Zoom hearing being conducted on the evaluation of the defendant. His attorney is Sarah Barger and Catherine Hapner. Ms. Barger is appearing, and I believe Ms. Hapner is unable to be here. Is that correct?
That is correct, Your Honor. She's in another hearing right now.
All right. So Ms. Barger will be handling it for this purpose, for this hearing. Appearing on behalf of the state's prosecuting attorney Collins. The defendant is charged with 3 counts of rape and 1 count of gross sexual imposition. Mrs. Collins, has the alleged victim or representative of the alleged victim been notified of the time, place, and purpose of this hearing, the right to be heard?
They have, Your Honor, and they will not be attending.
All right, thank you. All right, now Mr. Jones was ordered to be evaluated by the Forensic Evaluation Center. By order of the court, that examination was performed by Joy E. McGee, M.C. capital G.H.E.E., psychologist. Her evaluation was done on May the 8th. Her report was filed on May the 20th. The report indicates that she has determined that the defendant is capable of understanding the nature and objective of the legal proceedings and is capable of assisting counsel in his own defense. And so, therefore, it's her opinion that Mr. Jones is competent to stand trial. Now, does either attorney wish to present any further evidence on this matter?
No, Your Honor. No, Your Honor.
All right. Court then will find the defendant is competent to stand trial. The case will be restored then to the active docket. All right. And did we did not have a first pretrial, did we?
We had a first pretrial, and that was when this was filed. And,
oh, okay. All right. So we'll set a final pretrial then on this matter for June 25th at 1 p.m. And we'll set the trial date for July 24 at 8 a.m. Is this anticipated to be no more than 2 days, Mr. Collins, in your opinion?
Yeah, no more than 2, likely just 1.
All right. All right. Now, is there anything further than to be brought before the court at this time?
I don't know that, I guess this is a defense issue, but the defendant did not cooperate with the NGRI section portion of the competency evaluations. I don't know if we put on anything on the record for that.
Well, he hasn't entered a not guilty by reason of insanity plea, and so we refused to do it. The court just does that as a precautionary measure so that we can anticipate that, but since he declined to participate, as is his right, there's nothing more needs to be done, but thank you. That's on the record. Okay. Now, anything further then for Ms. Burgess? You and Ms. Hapner's discovery will be due by the final pretrial, and then when and if there are any pretrial motions, then those will need to be filed as well, so we get those matters decided before the trial date. All right. Thank you.
Thank you.
was trying to get
Just don't talk. Yeah. All right. This is case number 25 CR 67, State of Ohio versus Todd Richard Ray Jr. Now, you're Todd Richard Ray Jr.?
Yes, sir, and you're the first person that's actually said my name right in a while.
Okay. Just a lucky guess, I think. All right, Mr. Ray, you were indicted by the grand jury back on May the 6th on a charge with aggravated possession of methamphetamine, alleging that you knowingly obtained, possessed, or used methamphetamine, and that would be a violation of Section 2925.11 and proven, and that would carry, if convicted, a possible term of incarceration of 6 to 12 months and a fine of $2,500. Hold on here, I didn't get the arraignment sheet out here. Turn right to it. Now, you're entitled to have an attorney, Mr. Ray, and if you do not have the funds to hire one, the court will provide one for you at no cost. I see you did fill out the financial disclosure form. Is everything on this form correct?
Yes.
All right. You're employed, self-employed, or only?
Yeah, I've been doing lawn care service there in Greenfield.
All right.
Got about six or seven customers that I take care of their lawns.
All right. Now, the court will find that you're not able to employ your own attorney. Court will appoint Attorney Danielle Witt of Hillsborough to represent you. And in the absence of counsel, I'll enter a not guilty plea on your behalf.
Yeah, I'm trying to get into
Just don't talk. You need to learn that if I want you to talk, I'll ask you, and I'll give you a chance to ask questions in a minute, but don't interrupt me.
Sorry.
I'm filling out paperwork here. So the court enters a not guilty plea on your behalf. We'll set the first pretrial for June the 4th at 2 o'clock p.m. Your final pretrial. Hold on a minute. Wrong. Oh, here we go. Final pretrial will be June the 25th at 2 o'clock p.m. Trial date will be set for July the 10th at 8 a.m. Let's see. Now, were you released on your own recognizance in Greenfield?
Yeah, and some kind of assurance bond, a $10,000 assurance bond or something.
Appearance bond?
Yeah.
But you didn't pay. You didn't file a surety bond, though.
I didn't file it. The judge filed it for me. And like if I didn't show up to court, then I would have owed $10,000.
I got you. All right. All right. Well, I'm going to release you on your own recognizance only, and that's your promise to appear. If you fail to appear, you could be. Just be quiet. Don't interrupt me. If you fail to appear, you could be prosecuted for an additional felony, and if convicted, sentenced on that. No matter what happens in this case, we require to pay a deposit to cover your statutorily required fees of $171 within 30 days. You'll be under pretrial supervision of the probation department at 117 East Main Street in Hillsborough. Do you know where that's located?
No.
All right. Well, this is Main Street right here. So when you go out, come out the back door, come down there, turn left, go down to the traffic light. That's on the other side of the street, opposite the flagway station. Now you report there as soon as we're done. As soon as you sign your OR bond at the clerk's office, you'll be required to report to them once a week for 4 weeks, and after that, as they determine. They do have an office in Greenfield, so they do have reporting there. So let them know that's where you live. so that you can report there. You'll be under don't interrupt me. You'll be required to undergo random drug testing that may be ordered, provide phone numbers for home, cell, employer. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. If any treatment is indicated, you're to enroll in and follow that during the pendency of this action. Now you're also going to be, let's see, where's that financial disclosure form? Did you give that to me? There it is. All right, so you'll be under house arrest at your residence at 538 Jefferson Street in Greenfield. Now that means you have to be there unless you're working or going to and from work. You can go to and from any kind of medical appointments, court proceedings, in this or any other case. You can attend meetings with your attorney or probation officer in this or any other case. You can also go to any kind of job training that might be required or any educational programming of any sort. You can attend church services. Other than that, you have to be there at all times. And if you fail to comply, then the court could revoke that bond and have you held to further order of the court. Now, what that means is that when you're allowed to go and leave your house, you have to go directly to and from those places. You can't, make any side stops or go other places that are not permitted under the order. You'll be required to notify the probation department of your schedule when you're going to be going to and from different places, so they can check on that. And if you fail to comply with that order, then, as I said, the court could revoke that bond and have you held for further order. All right, now, have you been fingerprinted and photographed at the sheriff's office?
I gotta get there and do that today, I guess.
Yes, you will. All right, so what you're going to do then is you're going to get an assignment notice here with your date and times of your court appearances. And if you are able to do video conferencing on a computer, we can conduct the pre-trial by Zoom. But that way you won't have to come over here, but you'll need to let them know at probation if you have that ability. If not, you can go there. So after you get done signing your OR bond downstairs and making payment arrangements for your deposits, you're to go down to the probation department to report for pretrial supervision, and then report to the sheriff for booking after you report to the probation department. All right, now do you have any questions?
No, not really. I mean, as far as work goes, it's not really a set time. I normally get up about 8 o'clock in the morning, and then from like 8...
You'll just need to talk about that at the probation department. You let them know what your hours are, when you're going to go, where you're going to be generally. If you're out giving quotes for jobs or something, that's fine. Just that's what they're for. You communicate that to them.
And then I would like to try to get into an outpatient program before I come back from my first pretrial.
Well, you need to talk with your attorney about that and probation, okay?
Yes, sir.
All right. Okay. Case number 24-CR-173, State of Ohio versus Gerald Jason Conway. Present for the state's Assistant Prosecuting Attorney King. Present for the defendant's Attorney Jacob Wagner. Are you, is it Gerald or Gerald?
Gerald.
Gerald Jason Conway?
Yes, sir.
All right. Mr. Conway entered pleas of guilty to 3 counts of assault under 2903.13a of the Ohio Revised Code of 5th degree felony. The court referred the matter for a pre-sentence report. Have each of the attorneys had an opportunity to review a summary?
State has, Your Honor.
I have, sir.
All right. And Mr. King, has the alleged or the victims of the offense have been notified of the time, place, and purposes of the hearing right to be heard?
Yes, Your Honor. All 3 victims have been notified, and they elected not to attend the hearing this morning.
All right. Is there anything from the state regarding sentencing?
Thank you, Your Honor. The state would just ask that the court follow the joint recommendation, sentence the defendant to a term of 11 months on each count to be served consecutively, and the victims in this case have approved of this agreement. That's all, Your Honor. Thank you.
Mr. Wagner?
It is. Your Honor, and I'm sure Mr. King would just not purposely leaving out. My client was just nervous that the state would not oppose judicial release, Your Honor.
That's correct.
Okay. Go ahead and say that, Mr. Conway. Your Honor, we would ask the court to follow the recommendation. In thinking what to say here today, obviously I don't typically give a lot of sentencing, but I did want to just, on this case, I know the court doesn't look at these cases lightly on the assault on the corrections officer, but I can honestly say this, Your Honor, one is an officer of the court, and I'll stand behind it personally on my name. I've got to know Mr. Conway throughout this case. The guy I read in the discovery and the guy I looked at on the officer's video from the jail cell is not the guy I got to know. I will say this emphatically, and I stand by it. Alcohol is gasoline to this man. When it goes into his system, he's Jekyll and Hyde. The guy I got to know never missed an appointment, never missed a court date, worked through a children's services case, made sure his daughter, that his grandmother had legal custody because he had it before he goes off to prison here today. He was finishing jobs. He's an independent contractor, working anywhere from, last time I talked, he had a boom crane in Jackson, Ohio. So he's a legitimate guy who has a job, has a business, but he cannot drink alcohol, Your Honor. It's gas, like I said, gasoline to him. In trying to prepare for this case, I did speak to the officers, trying to see where they were. I do know, Your Honor, and he may speak on this, that Mr. Conway apologized to all the officers involved. Again, I know the court does not take these cases lightly. I'm simply saying, Your Honor, I think this man, maybe the judicial release hearing is more what I'll speak about. He can be productive, Judge, if he can just put down the bottle. I don't mean that mean to him. I think he understands that. But he can be a productive. He's a great father. It's just alcohol is an evil to him, Your Honor. That would be it, sir.
Mr. Conway, anything you'd like to say?
Yes, Your Honor. My behavior, that I'm embarrassed. That is not me, Your Honor. I consider myself a good man and a good father, hardworking. That's all I've ever known. I pick up that drink, and I'm a completely different person, sir. That's not an excuse for my behavior or my actions. The punishment that you're handing to me is, the hardest part about this is I have 3 girls, sir. My youngest is 6. That's the one that's in New York. She went with her grandmother. The pain that it's causing my kids is the biggest punishment to me, sir. I've got one getting ready to graduate this year, and when I had to come home and tell her that I couldn't be there, her heart was broken. I felt completely useless, sir. As a father, not being able to take that pain away from your kids really sucks. I apologize to the courtroom, to the officers again for my behavior.
Well, Mr. Conway, unfortunately, I think this is who you are. I'm looking at your record, and this isn't the first time you've had issues. And, it's been over a long period of time. Your first assault with intent to cause injury to an officer or fireman, or EMT, was in 2010 in Warren County, New York. There was another assault in 2022. It says act in a manner to injure a child less than 17 and unlawful imprisonment. Criminal tampering in 2021, endangering its welfare of a child in 2021. So, yeah, I know lots of drunks, see lots of drunks. Not every drunk's violent. I think, sometimes, what they say is that when a person gets drunk, it shows who you really are. And this is what's been happening. You had a 4-year prison term in 2010 for your previous assault on an officer, fireman, or EMT. It doesn't say which. I'm guessing it was an officer. And had a 4-year prison term. And in this case, you assault 3 different corrections officers in this incident. It's pretty serious. Well, I am going to file a recommendation regarding sentence. I'm going to withhold judgment on the judicial release issue because you've already served a 4-year prison term. Or I don't know how much of it you served. So I'm questioning whether judicial release really is appropriate or not in the matter. But actually, I'm not going to follow the recommendation because, quite honestly, I think that I have a lot of reservations about granting judicial release in this case. It's to order the court that you be sentenced on each of the 3 counts to a term of 9 months. Those are to run consecutively to each other for a total of 27 months. According to the Sheriff's Department, you were arrested on the 17th of November, released on the 23rd. Is that correct?
Yes, Your Honor.
All right, so that's 7 days of jail time credit. Upon completion of that prison term, the Adult Parole Authority may put you under post-release control supervision for up to 2 years. If they do, you'll be supervised by a parole officer on the terms they set. If during that period of time they determine that you have failed to comply with those conditions, you could be returned to prison to serve an additional period of up to 9 months for each single violation, up to a maximum of half of your prison term, or 13 and a half months for all violations. However, if you are convicted of a new felony while under post-release control, then in addition, whatever sentence the judge in the new case can impose upon that judge is also authorized to sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that sentence would run consecutively to the sentence in the new case. You're also ordered to pay the cost of judgment, grant, and execution's order. If you fail to do that, the court clerk could collect that through various means, including levy on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but once you get out, you could be permitted to do community service in this county and be given credit for each hourly work in an hourly rate set by the court. Each hourly work will reduce your judgment by that amount until paid in full. All right. Is there anything further from counsel?
There you go.
Yes. The court orders that the sentences be served consecutively to one another. The court finds that the basis for the consecutive sentences are that the parties, number one, have negotiated a consecutive sentence. The court has given less than the maximum. The sentence that is being proposed is not disproportionate to the harm caused to 3 separate officers, and is not disproportionate to the seriousness of the offense. Also, the court finds that the defendant's conduct is such that he's a danger to the community and to officers that deal with him. And so his criminal conduct and history demonstrates that that's necessary to protect the public from future crime by this defendant. And Mr. Conway, I'm going to say this. You've had plenty of time in your life to change. You haven't done it yet. And so that's why I'm taking the position I'm taking. And so I can tell you now, I'm not going to grant a judicial release early. And you only get one bite of the apple without the court's leave. I don't think that you're worthy of an early release based on the fact that you have a prior history for this exact offense, and you were given 4 years then. I see no reason why you should get an early release on these charges. But again, if you file your motion, I'll look at it, but I can tell you that it's going to be a high bar. All right. Anything further, counsel?
No, sir.
All right. You're remanded in custody.
Your Honor. Your Honor.
Can I have 1 second with him, Your Honor?
Sure.
May I approach, Your Honor?
You may.
For the next hearing.
Would you like Mr. McCollum up here, Your Honor?
Yes.
That's the right here, sir. Hold on.
Yes.
All right, this is case number 25, CR 46, State of Ohio versus Dustin Ray McCollum. Present for the State's Assistant Prosecuting Attorney King. Present for the defendant's Attorney Jacob Wagner. And are you Dustin Ray McCollum?
Yes, Your Honor.
All right, Mr. McCollum is charged with 1 count of pandering and obscenity involving a minor, a 4th-degree felony. This matter was set, I believe, for a plea hearing. Mr. King has the alleged victim of the offense or representative of the alleged victim been notified of the time, place, and purpose of this hearing, the right to be heard?
Yes, Your Honor. The representatives have been notified and they've elected not to attend the hearing this morning.
All right. The matter is currently set for trial for June the 9th. Mr. McCollum, I've been presented with a form that indicates you're going to plead guilty to this charge of pandering and obscenity involving a minor under Section 2907.321A5 of the revised code, and that is a 4th-degree felony. This document is 3 pages long. The last sentence on the document on page 3 reads, "I enter this plea voluntarily," and below that appears to be, there's a line that says signature of defendant. There's an X next to it. Is that your signature? There's
Yes,
Mr. Wagner's signature.
Yes, Your Honor.
When did you sign this, Mr. McCollum?
This morning.
And when you signed it, did you understand that it was an agreement to plead guilty, which means there won't be a trial? The next step in your case will be a sentencing.
Yes, Your Honor.
And when you came here this morning, had you already talked to Mr. Wagner about this and expected this agreement?
Yes, Your Honor.
When you went over it, is that what you expected it to be?
Yes, Your Honor.
And do you feel you had enough time to fully consider the matter before you made a decision to go ahead and sign this?
Yes, Your Honor.
Did you do that voluntarily?
Yes, Your Honor.
Right now, the agreement, as I indicated, says you're going to plead guilty to the charge, and on page 1 it states that you understand that the penalty for that could be 6 to 18 months imprisonment and a fine of $5,000. Do you understand that?
Yes, Your Honor.
Right. And in addition, under the law, a person convicted of this offense is required to be registered as a Tier 2 sex offender, which requires a registration period of, I believe, 25 years.
Yes, sir.
And it has to be every 6 months. So that would be a requirement that you'd have to register for that period of time. The particulars that would be described if you plead guilty and are sentenced. You understand that?
Yes, Your Honor.
Now, are you facing any felony charges in any other jurisdiction?
No, sir.
Okay. Are you currently on probation, community control, parole, or post-release control for a felony in any other jurisdiction?
No, Your Honor.
Now, under the law, Mr. McCollum, if you should ever be required to serve a prison term and complete that prison term, the law provides that it's mandatory that you be put under supervision by the adult parole authority for a period of 5 years. They will set certain conditions, and you'll be supervised by a parole officer as to those conditions. If during the period of time that you're being supervised, if that does occur, and you fail to comply with those conditions, they can return you to prison to make you serve an additional period of up to, in this case, 9 months for a single violation, or maximum of 9 months for all violations, because it's either half of the prison term or 9 months, whichever is more. However, if you are convicted of a new felony while under post-release control supervision, then in addition to whatever sentence a judge in the new case can impose upon you, the judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. Do you understand that?
Yes, Your Honor.
Now, under the law, I'm not required to sentence a person that's convicted of this offense to prison. I can impose what's called community control, or what most people know as probation. That means that instead of being sent to prison, you would be put under supervision of the probation department under the conditions set by the court for a period of up to 5 years. If during that period of time the probation department felt that you were not compliant, they would file a written notice of that with the court, give you a copy. There would be a hearing. You would be entitled to have an attorney to represent you at that hearing. If the outcome of that hearing was that you had failed to comply, then at that time the court could revoke your community control and then sentence you to prison for between 6 and 18 months and fine you up to $5,000. And if that occurred because you, in part or whole, because you've been convicted of a new felony and you received a prison term for that offense, that sentence and the sentence imposed in this case could be ordered to be served consecutively to one another, meaning one after the other. Do you understand that?
Yes, Your Honor.
All right, now, Mr. McCollum, the charge in this case alleges that on or about October 30, 2021 in Highland County, Ohio, you did, with knowledge of the character of material performance involved, buy, procure, possess, or control obscene material that had a minor as one of its participants in violation of Section 2907.321A5 of the Ohio Revised Code. So that's the charge of pandering obscenity involving a minor, the fourth-degree felony with the penalties that I've described. Now, do you understand what it is you're charged with, what the state said you did, when, where, how they led you did?
Yes, Your Honor.
And have you discussed the evidence in the case, the possible legal issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, Your Honor.
Are you satisfied with his advice and competence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Do you take any prescription drugs?
Yes, I do.
Did they interfere with your ability to understand what's going on or to relate your thoughts accurately?
No, sir.
Has anyone threatened you to make you plead guilty here today?
No, Your Honor.
Now, on page 2, there are a couple of lines printed in bold and underlined that read as follows. Defendant will enter a plea of guilty to the indictment. State and defense jointly recommend community control. Defendant shall be a Tier 2 registered sex offender. Is that your understanding of the agreement?
Yes, Your Honor.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, Your Honor.
Under the law, the matter of sentence is up to the judge, not the parties. So even though there's a recommendation as to what the sentence ought to be, the court's not required to follow that. The court could decide that's not the appropriate sentence and instead sentence you to a term of incarceration between 6 and 18 months and fine you $5,000. You understand that?
Yes, Your Honor.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No, Your Honor.
Now, you have certain constitutional rights you must understand before I can accept a plea of guilty from you. I have a right to counsel, and I believe you've employed Mr. Wagner to represent you. In the event that you did not have the funds to continue to pay Mr. Wagner, the court would appoint an attorney for you at no cost. So the reason I bring that up is I want to make sure you're not entering into this agreement because of the concern about being able to pay for an attorney. Is that correct?
You understand the question?
I didn't ask that very well. Let me rephrase it. You're not pleading guilty today
Yes, Your Honor.
because, well, wait till I finish my question. That your plea of guilty isn't because you're worried about being able to pay for an attorney. Is that accurate?
Yes, Your Honor.
Okay, thank you. I'm sorry I didn't say that very well. Now, You have the right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial day. After they are selected, the evidence is presented, and the judge instructs them on the law. And then that jury decides by unanimous verdict, meaning all 12 would have to agree on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you did not want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial. In that case, you would have what's called a court or a bench trial. That means that the judge is the one that hears the evidence instead of the jury. The judge is the one who applies the law and determines whether the state proved your guilt. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to confront witnesses against you in open court and to cross-examine them through your attorney. So what that means is that the witnesses against you would have to come into court and testify in front of you, your attorney, and anyone else that was present or observing. After the prosecutor's done asking questions, your attorney can ask questions. That's called cross-examination. The purpose of that is to try to bring out evidence that may help your side of the case. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you're entitled to use the power of this court to compel or force witnesses to come into court to testify on your behalf, just like the state. So, if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order called a subpoena. And that forces those people to come to court to be able to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come in and testify against you. Do you understand that?
Yes, Your Honor.
Under the Constitution, Mr. McCollum, you have a privilege against self-incrimination, which means you cannot be forced to give evidence against yourself in this matter at any time, including the trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there is a jury trial and you elect not to testify, the judge does instruct the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Under the Constitution, Mr. McCollum, you are presumed innocent of this charge or proven guilty by the state of Ohio on every essential element of this offense. What that means is the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused by being indicted. In fact, under the law, you're not required to present any evidence in your defense at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of the offense charged by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
Now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all of the rights that I have just described. If you change your plea today from not guilty to guilty, that's the opposite of not guilty plea. The guilty plea will admit the allegation in the indictment, admit that it's a crime, and that you committed that crime. And that plea will waive and give up all the rights I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what you're pleading. But with that exception, your plea of guilty would waive and give up your right to a jury or court trial. It would waive and give up your right to confront the witnesses against you and to cross-examine them through your attorney in open court. It would waive and give up your right to use the power of the court to compel or force witnesses to show up in court to testify for you, just like the state. It would waive and give up your privilege against self-incrimination, because if you say you're guilty, the state doesn't have to prove you're guilty. It would waive and give up your presumption of innocence, because if you say you're guilty, then the state doesn't have to prove you're guilty. Now, plea of guilty subjects you to being sentenced immediately by the court, and it waives or gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if you should be sentenced to the maximum sentence or under other limited circumstances, you could file an appeal. That would have to be filed within 30 days of your sentence and entry being filed. Do you understand all of that?
Yes, Your Honor.
And are you a U.S. citizen?
Yes, sir. Yes, Your Honor.
Now, do you have any questions about the charge or the possible penalty?
No, Your Honor.
You understand it?
Yes, Your Honor.
Have any questions about the plea agreement?
No, Your Honor.
You understand it?
Yes, Your Honor.
And again, you understand the recommendation on the sentencing is not binding on the court.
Yes, Your Honor.
Have any questions about the constitutional rights I've explained?
No, Your Honor.
You understand those?
Yes, Your Honor.
Have any questions about the plea of guilty, what it means, or what will happen if you enter that plea?
No, Your Honor.
Now, is there, do you understand?
Yes, Your Honor.
Now, is there anything you'd like to speak with your attorney about before we go any further?
No, Your Honor.
Then is it your decision to withdraw your not guilty plea and plead guilty to the charge and the indictment pursuant to the terms of this agreement that we've just gone over?
Yes, Your Honor.
All right. Then as to the charge, which alleges that on or about October 30, 2021 in Highland County, Ohio. You did with knowledge of the character of the material performance involved, buy, procure, possess, or control obscene material and having minor as one of its participants in violation of section 2907.321A5 of the Ohio Revised Code, charge of pandering and obscenity involving a minor, a fourth-degree felony carrying possible prison term of 6 to 18 months, fine of $5,000, at a designation as a Tier 2 sex offender registered. How do you plead?
Guilty, sir. Your Honor.
All right. Thank you. You can be seated. The court finds that on this day in open court, the defendant was advised of all his constitutional rights, made a no intelligent voluntary waiver of the same, pursuant to Criminal Rule 11. Plea is accepted, ordered, filed. Defendant is found guilty of the offense. The court orders that a pre-sentence report be conducted by the probation department. Bond would be continued, and here it is. The court will set the sentencing hearing for July the 2nd at 9 a.m. All right, is there anything further from counsel?
No, Your Honor.
No, sir.
All right, get your assignment notice from the bailiff and then report down to probation for your pre-sentence interview. Officer Benson's here. She'll get you quite and give you instructions. All right, thank you.
Thanks, sir. Question?
We'll go ahead and do Parr first. Okay, case number 24CR90, State of Ohio versus Todd Parr. Mr. Parr is appearing from the jail. This hearing is being conducted by Zoom. His attorney is Jacob Wagner, attorney from his office. Well, this is going to be a plea.
It is, sir.
All right. Okay. I want to continue this and do Mr. Certain first. I'll get him off the before we go into this plea. So,
Yes, sir.
if you would have Mr. Parr step out of the room and bring in Mr. Certain, then we'll do Mr. Parr next.
Yes, sir.
Yeah, he's there. All right. It's case number, 4 cases involving the same defendant. State of Ohio versus Michael W. Certain, 25CR25, 25CR59, 25CR75, 25CR76. Are you Michael Certain appearing there from the jail?
Yes, Your Honor.
All right. This is a motion this is scheduled for a pre-trial. There's also been a motion filed to recuse or to withdraw by Mr. Certain's attorney in 2 cases. Mr. Damon Davis. Mr. Davis is appearing by Zoom. Mr. Davis, I note that you don't have your suit coat or sports jacket on, and you'll notice on the email invites and in the local rules of court, attorneys are to dress the same as they would if they were appearing in court.
I apologize, Your Honor. I'm in my car.
Okay, well, I really don't care. As I said before, I have you doing this hearing as a courtesy, and I expect you to comply with the local rule and what's expected of any professional attorney. Now, Mr. Davis has filed a motion to withdraw in case number 25CR25. Well, and actually in all 4 cases. Now, the court had indicated previously when I arraigned Mr. Certain in case number 25CR75 and 76 that that would be a limited appearance for arraignment only. So the motion regarding those 2 cases, I'll go ahead and sign it. I don't think it was actually strictly necessary, but I'll go ahead and sign it so that it does show in the file that that's been granted. Now, with regard to the other 2 cases, Mr. Davis, in 25CR25, if you would explain a little more on, I forgot to indicate Ms. Collins on behalf of the state is also present. If you could indicate to me what it is, the reason that you are wanting to withdraw from 25CR25, because this case was set to go to trial, you entered an appearance, and the attorney had been appointed for Mr. Certain and was allowed to withdraw. So why are you wanting to withdraw from this case?
Yes, Your Honor. When we entered our appearance, we did have a fee agreement with Mr. Certain. Once he ceased our communications with our office. Once he was taken back into custody, we were in contact with representatives of his who indicated to us that by a certain date they would either make a payment to fill the fee obligation or they would look elsewhere. And we've never heard back from them.
Well, let's see. This case was originally set for trial May of 15. Okay, and then Mr. Certain failed to appear. So, but I believe you had entered an appearance prior to that.
Yes, Your Honor.
And so then he was taken into custody. And I guess my question is, why would you enter an appearance in a case that was scheduled for trial if you didn't have the entire fee that would justify it? Because what you're doing is putting the court and the state in a situation where we had to bump the case. Even if he had showed up, we would have had to probably bump the case because you weren't ready. And then I set the case for trial day with no objection, and now you went out because you didn't get all your money. So my question is, I have a problem with the professionalism of taking enough money to enter the case to get the case continued, and then but not enough to try it, and then use that as a basis to withdraw when a case is set for trial. Because now, if I grant your leave to withdraw, then Mr. Certain's either going to have to hire another attorney, or if he can, we're going to have to appoint someone that's going to kick the case down the road another 6, 8, 10 weeks. all because you didn't get enough money up here. So I guess my position is, I think that when an attorney enters a case in which there's been an appointed counsel and it was set for trial, and a privately retained attorney comes in, they need to be on the hook for the trial. Now, did you not agree to that when you came into the case?
I know we scheduled that was planned that would have been taken care of before the trial. If Mr. Certain had been in communication with us throughout that period after the cases, maybe something could have been worked out. But at this point, I believe there's an actual conflict under the professional rules of conduct, Rule 1.8, that actually requires us to withdraw.
I don't know that that's correct. Why do you think that requires you to withdraw? I mean, you've created the problem by taking the case and entering an appearance without making sure you had enough money to try the case. You know, when you come in and substitute as a counsel of record, you know, this could go on ad nauseum. You know, the defendant could keep coming up with just enough to get somebody to enter an appearance and ask for a continuance and get the case kicked down the road, and then not pay the balance, and then the next thing, same thing over and over again. I mean, it's not professional. You know, I would expect that if you're going to file an entry of appearance in a case, and where we already have an attorney who is representing him and has been prepared for the trial, and you enter the appearance, that you enter the appearance with the expectation that you're going to try the case, and you make sure you secure enough to do that. Now, you failed to do that, so that's my problem. I mean, and I think it's a problem for you because I think it's unprofessional. And you're really assisting the defendant in basically screwing up the court's docket.
That was not material, Your Honor, at all. So my apologies to the court for that. We are not local counsel, so that the lack of fee would present an unreasonable financial burden on us as a firm.
And again, if that's the case, why did you take the case and enter an appearance? Why?
Your Honor, my answer is the same. We had a fee agreement that we had no reason to believe he would renegotiate.
But that agreement didn't include your commitment to try the case regardless of whether he ended up to it. And that's where I have the problem. Again, you know, this wasn't where you appeared before at the first time for the arraignment and took the case on initial appearance. This is where we have gone through discovery, we've got the case set for trial, and now you're going to come in and you have him sign a fee agreement without guaranteeing that there's enough there for you and your firm to try the case. And that is where I think there's a problem. Because you're screwing with the court's docket, you're delaying justice to your client. Because now, if I grant this case is going to be kicked down the road. And I'll have to get another attorney to come in. And that's going to harm him because it's going to cause a delay that's attributable to unavailability of counsel and your withdrawal. And that's the whole problem I have. So I'm going to, I assume, Mr. Certain, that you don't want him to try the case, since he says that he doesn't feel that he thinks there's a conflict. And I assume you don't want an attorney that's not fully in your corner, so to speak, with your financial arrangement to continue to represent you. So I assume you're agreeing to this withdrawal?
I mean, I didn't want to agree to it.
Yeah.
I didn't understand there was a conflict. I thought it was retaining for the first cases, and then it seemed like there was a conflict as the other cases come on.
Well, he's not on the hook for the later cases, although he did enter an appearance, Mr. Davis, you did enter an appearance in the second case, and apparently didn't realize it, and I'm willing to let you off on that one too, because I know the retainer was on the first case. So, but the problem is, so I don't know what's happened here, in terms of, and I don't know what work your firm has done. It seems to me you're creating also potentially a fee dispute here, because at this point you've been here one time and then had this hearing. So I'm going to go ahead and grant the motion, but I'm going to tell you this, Mr. Davis. I am going to consult with Well, I'm going to look at the rule to determine, just exactly what I think, what the obligation of an attorney is that enters an appearance in a criminal case that's scheduled for trial, and then seeks to, within a month, back out because there's not enough money there to go forward any further. And I don't know how much the arrangements were, how much has been paid, how much was promised, but it would seem to me, and I'm going to tell you this in the future, if you want to enter an appearance in this court, the first thing I'll do is I will make you put on the record that you have enough money to keep the case, regardless of whether it takes one hearing or a 20-day trial. You're going to be on the hook because this is ridiculous. This is not the way cases should be handled. And I don't think it's fair to the courts, not fair to the states, not fair to your client. So with that, I'm going to grant your motion to withdraw.
Thank you, Your Honor.
So, Mr. Certain, I will contact another attorney to see if they will take the case to represent you. The case will have to be put on the inactive docket, and your speedy trial time is going to toll because you don't have an attorney. We'll have to, we'll try to do that today and make sure that we can get that done. Right now, I'm going to leave the trial on and let that new attorney then, when they come in, decide whether or not they want to ask for a further continuance to try the case. If there needs to be a continuance for purposes of a trial, I understand that. Again, that's where we were with Mr. Davis, and now that's where we are again. So, as you can see, I'm not happy about it, but I don't think there's any choice because you need to have an attorney that, there's no conflict with, and he's the one that felt there was a conflict because you're not paying him. So, I don't like that at all. There's not a thing I can do about it. Because if I forced him to represent you and you went to trial and you were convicted, that'd be an automatic ground for appeal, and most likely the Court of Appeals would reverse it. So that's why I had to do what I did. So we'll see about getting you an attorney hopefully by tomorrow, if not by the end of the day. Thank you.
Thank you.
All right, Mr. Parr.
Parr.
Contact Jeff Blosser and see if he'll represent certain. I'm not going to do that.
Okay.
Yeah, call Jeff Blosser.
Okay.
Because I don't want him to get the same attorney he had before, simply because he wanted a new attorney, he got himself a new attorney, so we're not going to play that game.
Okay.
All right, we're back on record in case number 24 CR 90, State of Ohio versus Todd Lester Parr, and you're Todd Lester Parr appearing there for the jail. All right, Mr. Parr's attorney is Jacob Wagner. He's appearing from his office. Appearing from the prosecutor's office on behalf of the state is prosecuting attorney Collins. The defendant is charged with failure to register a change of address as a registered sex offender. This is a final pretrial, and I have a trial or a plea of guilty here, Mr. Parr, which indicates you're going to withdraw your not guilty plea, plead guilty to the charge. Failure to register a change of address as a registered sex offender of third-degree felony under 2950.05 F1 of the Ohio Revised Code. I'm going to hold the first page of the agreement up to the camera and ask if you recognize that. All right, and on page 3, there's a sentence that reads, "Enter this plea voluntarily." Below that, it appears to me to be the signature Todd Parr. I'll hold that up to the camera, and is that your signature?
Yes, sir.
And when did you sign this, Mr. Parr?
Yesterday.
When you signed it, did you understand it was an agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing?
Yes, sir.
And did you have Mr. Wagner go over this with you and explain it to you and answer any questions?
Yes, sir.
Feel you had enough time to fully consider the matter before making the decision?
Yes, sir.
And did you enter into this agreement to plead guilty voluntarily?
Yes, sir.
All right, now the agreement on page 1 indicates you understand there could be a penalty imposed if convicted of between 9 and 36 months incarceration and a fine of $10,000. You understand that?
Sure.
Are you facing any felony charges anywhere else?
No.
Are you currently on probation, community control, parole, or post-release control for a felony in any other jurisdiction?
No, just in prison right now.
All right. Now, under the law, if you are convicted of this offense and sentenced to prison, upon completion of that prison term, if possible, the Adult Parole Authority may exercise the option to put you under post-release control for a period of up to 2 years. If during that period of time they determine that you have failed to comply, they could return you to prison and make you serve an additional period of up to 9 months for any one violation, up to a maximum of half of your prison term for all violations. However, if you violate a new felony, or you commit a new felony, then in addition, whatever sentence a judge in the new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new case. Do you understand that? Now, under the law, this is not a mandatory prison term, so the court is authorized to sentence you to a term of community control of up to 5 years, meaning you'd be supervised by the probation department under terms set by the court. Now, if during that period of time probation felt that you had failed to comply, they would file a written allegation of that with the court and give you a copy. There would be a hearing. You'd be entitled to have an attorney at that hearing. If the outcome of the hearing was you failed to comply, then at that time, the court could revoke your community control and sentence you to a period of between 9 and 36 months incarceration and fine you $10,000. And if that was in part or whole due to a conviction on a new felony, and you received a felony, a sentence in that new felony case, the sentence in this case and that case could be served or to be served consecutively, meaning one after the other. Do you understand that?
Sir.
Now, the charge in the indictment alleges that beginning on about April 1, 2024, continuing thereafter in Highland County, that you, being a registered sex offender convicted out of the Union County Common Pleas Court case number 2010-CR-0114, and according to the requirements of the law after 2008, having a duty to register a change of address, failed to provide notice of any change of address within 20 days by written notice, and was reckless in that regard, having previously been convicted of unlawful sexual conduct of the minor, a felony of the third degree on November 5, 2010, being a Tier 2 registered sex offender and having duty to register semi-annually 20 days before an address change within 3 days of an address change, and that you had previously been convicted of failure to register a change of address as a registered sex offender in Highland County Common Pleas Court case number 21-CR-56 on September 22, 2021, in violation of section 2950.05 F1. Now, you understand what it is you're charged with, Mr. Parr, what the state said you did, when, where, and how they alleged that you did it?
Yes, sir.
Have you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, possible defenses you might try to raise in trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with this advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
Yes, sir.
Has anyone threatened you to make you plead guilty?
Yes, sir.
Now, on page 2, there's a couple of lines in this agreement that read as follows. Defendant shall honor plea of guilty to the indictment. State defense jointly recommend 18 months incarceration. Is that your understanding of the agreement?
Yes, sir.
Anyone promise you anything other than that to get you to plead guilty?
Yes, sir.
Now, under the law, Mr. Parr, the matter of sentence is up to the judge, not the parties. And so even though there's a joint recommendation as to the sentence, the court's not obligated to follow that if you plead guilty or are found guilty. The court could impose any sentence that it's deemed appropriate under the law that's applicable to this charge. You understand that?
Yes, sir.
All right. Now, do you have, first of all, do you have any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
Sir.
All right. Now, you have certain constitutional rights you must understand before I can accept the plea. First of all, you have a right to counsel. Mr. Wagner has been appointed to represent you. That appointment is not simply to work the case out, but to provide any defense that may be available to you under the law that you would like him to provide. So if you decide that you don't want to do this, that you want to defend against the charge and go to trial, he'll continue to represent you and do that. You understand that?
Sir.
All right. Now, under the Constitution, you have a right to a jury trial in this matter. in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After those 12 are selected, the evidence would be presented, and the judge would then instruct the jury on the law. And that jury would decide by unanimous verdict, meaning all 12 would have to agree on whether you were proven to be guilty or not. If you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means you give up your right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning the judge would be the one who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Sure.
Under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney in open court. What that means is the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, Mr. Parr, you have a right to use the power of the court to compel or force witnesses to be in court to testify on your behalf, same as the state. So if you have witnesses you're uncertain are going to come in voluntarily, at your request, the court issues a court order called a subpoena, and that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can. It's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it, except in one situation. If you're in a jury trial, if you have a jury trial, and you do not testify, the judge instructs the jury that because it is your right, they cannot consider it for any purpose. Do you understand that?
Sir.
Under the Constitution, you have a presumption of innocence, which means you cannot, that you are presumed innocent of the charge until proven guilty by the state of Ohio on every essential element of the offense charge. So you're not required to try to prove anything simply because you've been indicted. In fact, under the law, you don't have to present any evidence at trial on your own defense. You may, but you're not required to. But whether you do or not, the burden of proof is still on the state to prove your guilt by proof beyond reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Sir.
Now, originally entered plea of not guilty, Mr. Parr, which denied the allegation, and the indictment denied you committed a crime and exercised all the rights I just described. You change that plea today from not guilty to guilty, it is the opposite of the not guilty plea. The guilty plea means that you admit the allegations in the indictment, admit that they're a crime, that you committed the crime, and that plea waives, gives up all the rights I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea, but with that exception, your plea of guilty waives, gives up your right to a jury or court trial. Waives, gives up your right to confront the witnesses against you in open court and to cross-examine them through your attorney. Waives, gives up your privilege against self-incrimination because you're saying you're guilty, that's what you use to find you're guilty. Waives, gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court, and finally, the waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence, or under other certain limited circumstances, an appeal could be filed. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that? And are you a U.S. citizen?
Sir.
All right. Now, Mr. Parr, do you have any questions about the charge or the possible penalty?
Yes, sir.
You understand them?
Yes, sir.
Do you have any question about the plea agreement?
No, sir.
You understand it?
Yes, sir.
And again, you understand the recommendation on sentencing is not binding on the court.
Yes, sir.
Do you have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir.
You have any questions about the plea of guilty, what it means, and what will happen if you enter that plea here today?
No, sir.
Now, I didn't say this at the beginning, but Mr. Wagner, you and your client are both agreeable to this matter being conducted on Zoom rather than in person.
We are, sir. Excuse me,
You're all right,
yes.
all right with that, Mr. Parr?
Sir.
All right. And since I did say this at the beginning, you do have a right to talk to your attorney during the hearing, so if there's anything you'd like to speak with him about, I can put you and him into a breakout room. It'll be just the two of you on the screen talking to each other. None of the rest of us will see you or hear you, and the deputy will step out of the room while you're consulting with your attorney. Now, do you need to talk with him about anything, or are you ready to go forward?
Looking forward.
All right. Then, as to the charge, which alleges that beginning on or about April 1, 2024, continuing thereafter in Highland County, that you did being a registered sex offender convicted out of the Union County Common Pleas Court, case number 2010 CR-0014, according to your requirements of the law after 2008, having a duty to register a change of address, failed to provide notice of any change of address within 20 days by written notice, was reckless in that regard, and having been previously convicted of unlawful sexual conduct with a minor, a felony of the third degree on November 5, 2010, and you're being a Tier 2 registered sex offender and having a duty to register semi-annually 20 days before address change and within 3 days of address change, and you had previously been convicted of failure to register a change of address as a registered sex offender in Highland County Common Pleas case number 21 CR 56 on September 22, 2021, violation section 2950.05 F1 of the Ohio Revised Code, a third-degree felony carrying a possible prison term between 9 and 36 months and a fine of $10,000. How do you plead?
Guilty.
All right. The court finds on this day in open court, the defendant was advised of all his constitutional rights, made a no intelligent voluntary waiver of the same pursuant to criminal rule 11. Please accept an order filed. Defendant is found guilty of the offense. The court will proceed with sentencing forthwith, given the previous history of Mr. Parr, the criminal history, the previous conviction for this, and the fact there's a stipulated recommended sentence. Now, Ms. Collins, is there anything that you would like to say regarding this matter?
We would only ask the court to follow the joint recommendation.
All right, and Mr. Wagner, anything you would like to say?
Your Honor, we would ask the court to follow the joint recommendation of the parties. And I'm not quite sure why I say this if I spent some time with Todd, Your Honor. I don't know if there's any program or anything the court would be approval of. This is a situation where, I'm not defending Todd's actions, but he's in a cycle. He goes to jail, he goes to prison, he gets out, he's homeless, then he doesn't register. Then he gets in jail, then he gets in prison, then he comes out and he's homeless. If he doesn't fix this, I guess, Your Honor, or maybe if there's any program in prison he'd be qualified for, this is just going to be a cycle we're going to see. And Todd and I talked about that, sir. But we would ask the court to go along with the deal, Your Honor.
Mr. Parr, anything you'd like to say?
I'm sorry.
You're serving a sentence right now. I believe you're going to be finished with, I think, on the 29th. Is that correct?
Yes, sir.
And what was that for?
Domestic violence.
Is that out of this county or another county?
Ross, sir.
Ross, okay. All right. Well, that's right, because you were indicted while you were in prison on this case, it looks like. So, well, Mr. Parr, I know they do have counselors and so forth in the prison that will help people with reentry, and there are some reentry programs that are available through our local community action organization, and other counties have other agencies. You need to make some sort of plan when you get out this next time so that you don't have this situation where you're homeless, but you need to take charge of your life too. You just have to make plans and start anew if you're going to change this cycle. Otherwise, you're just like Mr. Wagner said, going to be in and out of prison the rest of your life. So it's a judgment order of the court that you be and are hereby sentenced to a term of 18 months in prison, which sentence will run consecutively to the one that's currently being served from Ross County. And there'll be 0 days for credit since he's not served any days in local jail for that time. Upon completion of the sentence, Mr. Parr, the Adult Parole Authority may put you under post-release control supervision for a period of up to 2 years. If they do, you'll be supervised by a parole officer the terms they set. If during that period of time they determine that you fail to comply, they could return you to prison and make you serve an additional period of up to 9 months for any one violation, up to a maximum of half your prison term, which in this case is the same, 9 months for all violations. However, if you're convicted of a new felony while on post-release control, then in addition, whatever sentence a judge in a new case could impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in the new case. You're also ordered to pay the court costs, which judge will grant an execution's order. If you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of the sentence, not while you're in prison, but once you get out, the court could permit you to do community service and give you credit for each hour you worked in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Also remind you that when you get out, you're still under the obligation to register. And so you need to make sure that you register with the sheriff of the county where you are released to as soon as you get released. All right. Anything further, counsel?
No, sir.
All right. You're remanded back to custody. Thank you.
Thank you, Your Honor.
Jared. All right, this is case number 24, CR 162, State of Ohio versus Jared Wayne Mick. And am I pronouncing that correctly, Jared?
Yeah.
All right.
Thanks.
You're Jared Wayne Mick?
Yes.
All right. Mr. Mick's appearing from the jail. His attorney is Caleb Johnson. Washington Courthouse is appearing by Zoom as well. And Mr. Johnson, are you and your client both in agreement this matter can be conducted by Zoom rather than in-person appearance in the courtroom?
Yes, Your Honor.
Right. And you're all right with that, Mr. Mick? Okay. Since you're not seated in the courtroom next to him, if you have any questions during this hearing, you let me know, and I'll put you and him in what's called a breakout room. It'll be just the two of you on the screen. No one else will be able to see you or hear you. And the deputy will step out of the room while that conversation is taking place, okay? All right. Now, the defendant is charged with assault and strangulation, and Ms. Collins has the alleged victim of the offense been notified of the time, place, and purpose of this hearing, the right to be heard?
She has, Your Honor, and she will not be attending the hearing.
All right. So Mr. Mick is charged with assault, a fifth-degree felony, and strangulation, a fifth-degree felony. And this is a final pre-trial, and I believe the trial is upcoming in June. Mr. Mick, I have been presented with a plea of guilty form, which indicates that you're going to plead guilty to count one, the assault, under 2903.13a of the Revised Code, fifth-degree felony. Now, this is a 3-page document, and I'm going to hold up to the camera the first page that has your name, case number, plea of guilty form. And once you take a look at that, make sure that you do recognize that form. You recognize that?
I guess. I can't really tell. I can remember.
Right there, you see your name?
Yes, okay. Yes, I remember.
Okay. Now on page 3, there is a sentence that reads, I enter this plea voluntarily. And right below that, there's a signature line for signature defendant. And I'm looking at what appears to be the signature of Jared Mick. I'll hold that up to the camera and ask if that is your signature there.
My signature, yes.
Do you know when you signed this, Mr. Mick? When did you sign this agreement?
I'm not exactly sure what day. It's been here recently.
Okay. Do you remember, Mr. Johnson, what date it was?
Yes, Your Honor. It was May 19th.
Okay. So this is a couple of days, not quite 3 days ago. And Mr. Mick, did you understand when you signed this agreement that it was an agreement to plead guilty so that it means there won't be a trial? The next step in your case will be a sentencing hearing?
Yes.
And did Mr. Johnson go over this with you and explain everything to you and answer any questions you had before you signed it? You had to speak up.
Yes.
Okay, thank you.
Yes.
And you feel you had enough time to fully consider the matter before you made the decision to sign it?
Yes.
And did you do that voluntarily?
Yes.
All right. And you're going forward today voluntarily as well?
Yes.
All right, so as I indicated, the first page says you're going to plead guilty to the charge. And before we go any further, I asked you that, didn't I? Okay. And so it further states on page 1 that you understand that it could bring a possible sentence of between 6 and 12 months in prison and a fine of $2,500. You understand that?
Yes.
And are you facing any charges anywhere else, Mr. Mick?
Nothing more. No.
Are you currently on probation, community control, parole, or post-release control for a felony?
No. This is my first one.
All right. Now, under the law, in the event that you are sentenced to prison and complete your prison term, upon completion of that sentence, it is possible that the Adult Parole Authority could put you under post-release control for a period of up to 2 years. And if they did that, you would be supervised under a parole officer under the terms they set. And if they decided that you had failed to comply, then they could return you to prison to make you serve an additional period of up to 9 months for any single violation, up to a maximum of half your prison term for all violations. However, if you're convicted of a new felony, then in addition to whatever sentence the judge in the new case can impose upon you, that judge can also sentence you for committing that offense under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. Do you understand that?
Yes.
Now, I'm not required by law to sentence you to prison for this offense. I can give you what's called community control or probation. What that means is that instead of going to prison, you would be put under the supervision of a probation officer for a period of up to 5 years under the term set by the court. If during that period of time the probation department felt that you had failed to comply with those conditions, then they would file written notice of that with the court, give you a copy. There would be a hearing. If the outcome of the hearing was that you had failed to comply, then at that time the court could revoke your community control and sentence you to the 6 to 12 months in prison and fine you $2,500. And if that occurred in part or whole because you were convicted of a new felony while on community control and sentenced to prison for that offense, the sentence in this case could be ordered to be served consecutively to the sentence in that case. Do you understand that?
And is there a possibility, Your Honor, I get time served?
You get credit. Oh, yeah. You get credit for any time you've been in jail, yes. Yeah.
No probation for my first offense?
If you don't get probation, you would get credit for time served. But if you get probation, the period of probation runs from the day that you're granted probation. Okay? Does that answer your question?
I think so.
Okay.
Thanks.
Okay. Now, the charge in this case alleges that on or about October 17, 2024 in Highland County, Ohio, you did knowingly cause or attempt to cause physical harm to V or the V's unborn, and the assault occurred in or on the grounds of a local correctional facility. The victim was an employee of the facility or probation department or was on the premises for business purposes as a visitor, and you were in custody of the facility in violation of Section 2903.13a of the revised code. So that's the charge of assault with the penalties I just described. Now, Mr. Mick, do you understand what it is you are charged with, what the state said you did, when, where, and how they alleged that you did it?
No, I'm charged with yes.
And have you discussed the charge, the evidence in the case, the legal issues in the case, possible defenses you could try to raise at trial, and possible outcomes of a trial with your attorney?
Yes, I am.
Are you satisfied with his advice and competence in this matter?
Yes, Your Honor.
Now, are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Are you taking any medications, prescription medications?
Yes, Your Honor.
Pardon me?
Yes, Your Honor.
And do they interfere with your ability to understand what's going on here or to convey your feelings accurately?
No, they don't interfere.
All right. Now, has anyone threatened you to make you plead guilty here today?
No.
Right now, the agreement states on page 2, it looks like about 3.5 lines that are underlined in bold, printed in bold. Defendant shall honor plea of guilty to count 1. State will dismiss count 2. State defendant will jointly recommend community control, continued mental health treatment, and support defendant's intent to relocate Massachusetts pursuant to interstate compact while on community control. Is that your understanding of the agreement?
That was my understanding of the agreement, yeah.
All right. Has anyone promised you anything other than that to get you to plead guilty here today?
No.
All right. Now, under the law, Mr. Mick, the matter of sentence is not up to the parties. And so even though both parties are in agreement, in the event that you plead guilty and I decide that that's not the correct sentence, you could receive a sentence of 6 to 12 months in prison and a fine of $2,500. Do you understand that?
Yes.
Do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No.
All right, now you have certain constitutional rights, you must understand, before I can accept a plea. First of all, you have right to counsel. I believe Mr. Johnson is employed to represent you. Now, in the event that you were not able to pay him, the court would still give you an attorney at no cost. And the reason I say that is to make you understand that if you can't afford to pay your attorney, you don't have to plead guilty. We would get you an attorney to do that. Do you understand that?
Yes.
Okay. Now, you have a right under the law to have a trial by jury on this charge, Mr. Mick, in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After those 12 are selected, the evidence will be presented. The judge would instruct them on the law, and then that jury would have to decide whether or not the state proves your guilt by unanimous verdict, and that means all 12 of them would have to agree. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that? Now, under the Constitution, Mr. Mick, you have a right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're uncertain are going to come in voluntarily, at your request, the court issues a court order, which is a subpoena, and that forces those witnesses to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come into court to testify against you. Do you understand that? I didn't hear you.
Yes, I guess you're.
Okay. Now, under the Constitution, Mr. Mick, you have a privilege against self-incrimination. What that means is you cannot be forced to give evidence in this matter at any time, including in the trial. No one can ever make you testify. The prosecutor can't, the judge can't. You make the decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one case. If there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yeah.
All right. Now, under the Constitution, you're presumed innocent of the charge till proven guilty by the state on every essential element of the offense charge. What that means is that the burden of proof isn't on you to try to prove that you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Yeah, I guess.
All right. Do you have any questions about it?
Yeah, I need to talk to you, thanks for that.
You'd like to speak to your attorney? Okay. All right, I'm going to put the two of you in the breakout room, and there's going to be a button come up on the screen that says join breakout room. You'll click on that, and then it'll be just you and Mr. Johnson there. And when you're done, you'll have to click leave breakout room, and then there'll be another button to re-enter. Then you'll have to click on that. So I'm opening that now. Oops, that button. right, case number 25-CR-73, State of Ohio versus Joseph N. Oliver. You're Joseph N. Oliver, appearing there for the probation.
Yes, Your Honor.
All right, Mr. Oliver is represented by Attorney Jacob Wagner. This is a Zoom hearing. Mr. Oliver is appearing for the probation department. Mr. Wagner is appearing from his office, appearing for the prosecutor's office, representing the state. McCollum, defense charged with failure to comply, a third-degree felony. This is a first pretrial, actually final pretrial, and trial set for July the 7th. All right, discovery complete then?
Yes, Your Honor, this is the first pretrial, though, not the final.
Okay, well, it was originally set, according to the arraignment entry for today's the 21st of May. I don't know why I said that. All right. So you got your discovery, Mr. Wagner?
I do, Judge.
All right, your discovery will be due by the final pretrial.
Yes, sir.
You anticipate any pretrial motions?
Not at this point, sir.
All right, and have you received a written plea offer yet?
I have, sir.
Is your defendant client aware of it?
He is not, Judge. He's out. I just need to get a hold of the office.
All right, so Mr. Oliver, contact Mr. Wagner after you get done there at the probation department about an appointment to discuss your case. All right?
Yes, sir.
All right, thank you. All right, we're going to let
Thanks, sir.
Mr. All right, we're back on record on State of Ohio versus Jared Wayne Mick. Now, Mr. Johnson, is your client ready to go forward?
Yes, he is, Your Honor.
All right. Now, Mr. Mick, can you understand the charge against you and the penalties? You need to speak up, okay?
Yes, Your Honor.
All right. May you have any questions about the plea agreement at all?
Do you have any questions about
Do you have any questions? All right. You understand them?
Yes.
Okay. Do you understand the constitutional rights I explained to you?
Yes, Your Honor. Thank you.
And you understand what the plea of guilty means and what will happen if you enter that here today?
Yes.
All right.
Yes, sir.
Then is it your decision to, also, you are a U.S. citizen?
Yes, Your Honor.
All right. Then is it your decision to withdraw your not guilty plea and plead guilty to the charge under the terms of this agreement that I've gone over with you?
Yes, Your Honor.
All right. Then as to the charge which alleges that on or about October 17, 2024 in Hiding County, Ohio, you did knowingly cause or attempt to cause physical harm to V or the V's unborn. The assault occurred in or on the grounds of a local correctional facility. The victim was an employee of the facility or probation department or was on the premises for business purposes or as a visitor, and you were in custody of the facility in violation of Section 2903.13a of the Ohio Vice Code. The charge of assault of the fifth-degree felony, carrying a possible penalty of 6 to 12 months and imprisonment, a fine of $2,500. How do you plead?
Yes, Your Honor.
All right, thank you. The court finds on this day in open court, the defendant was advised of all his constitutional rights and made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal Rule 11. The police accepted an order filed. Defendant is found guilty of the charge. In count 1, count 2 is dismissed. Court will order a pre-sentence report and will ask that to include the assessment for treatment for mental health issues. Bond will be continued, and we'll set the hearing for sentencing on June 25. Are you available that morning, Mr. Johnson?
I am, Your Honor, but if I may, I would ask that, and I'm not trying to hurry anyone up, but I would like to get him in a little bit sooner if possible, not to have any sort of rush on the PSI, but it is my understanding that there is a pretty thorough history, which is, I think, a good starting point for a CSI or a PSI already in the record. There's actually the two evaluations that are in there. So I think that both of those provide a lot of insight. If we could maybe just, I guess,
I'll get my calendar here. Generally, they like 30 days to prepare a report because in addition to the mental health issues, there's also other things they have to investigate. But I can probably expedite this a little bit. Just try to look at the calendar.
He can waive it.
Today is the 21st, okay? Let's take a look at the week of June the 9th and see what we have that week.
Mr. Johnson, you can ask the court to waive it.
Oh, okay. We are okay with a PSI being waived. The understanding was from probation, talking to them, that Judge, you would want that PSI no matter what, and that there really wasn't.
Yeah, and I do wish to have a PSI. Plus, we need to have time to allow for the transfer to Massachusetts under the compact, and so that's going to take a little bit of time, I think. But so I wanted to give probation the ability to do that, so that when I do sentencing, we can hopefully he can leave the facility and get transported right away. Because I would hate to just put him out here and leave him kind of in the local area with I don't know what his housing arrangement could be or whatever. But that would be
So I spoke with Ms. Sturgill, and she indicates that I'm not sure even that they're going to have the compact thing done before the 25th. It takes longer than that. But she did indicate that they would do a pass, the pass for him to go. Right. So we have access. I understand the court wants the PSI and for the time, but I don't think that's going to change anything.
Well, I don't know. I don't have any of that information. I mean, you guys know what you do. I don't. I'm the one that's got to sentence him, and I don't know what's in your mind or Mr. Johnson's mind.
I do have his CCH and am familiar with him from county court. I'm not uncomfortable with waiving, and I don't think that continuing it till, the sentencing until the end of the month is going to give the time that's needed for the whole interstate compact thing to be finished. I think it takes longer than that.
All right. Well, Mr. Johnson, what's the arrangements for him if he gets released?
My dad,
Your dad?
No, Your Honor. I would be calling his sister and immediately arranging for the pickup.
Okay. Well, he would have to go to the probation department first, so he's probably going to have to be in town for at least a couple of days to get that arranged, get the pass and so forth. Now, you have something you want to say, Mr. Mick?
Yeah, my dad, I respect my dad. He lives on Trucking Road in Greenfield.
He lives over there?
Huh?
Does he live there?
Yeah, he lives on Trucking Road in Greenfield, Ohio. He lives out right across the bridge.
That's a terrible idea. That's where he is, and by all accounts, Mr. Mick is a genuinely good person and super nice when he's on his medication. However, when he's at that residence, he uses meth.
No.
So,
I don't.
If we could arrange for him to remain in jail until his sister can come pick him up, I think that would be the best option.
All right. Well, if both parties are in agreement that pre-sentence be waived.
Yes.
Yes.
I live under the bridge.
All right. All right. Well, then I'll go ahead and proceed with sentencing. Ms. Collins, anything more you would like to say?
Your Honor, according to Mr. Mick's CCH, he only has prior misdemeanor offenses. Those both have been in county court. And like I said a minute ago, I think Mr. Mick's underlying issue, definitely a mental health issue. And unfortunately, he exasperates that by the use of illegal drugs. Hopefully, by getting with his sister, somebody that will monitor him and monitor his medication intake, he's not somebody that anybody is going to ever have to deal with again. So based on that, we would ask the court to follow the joint recommendation of the parties.
All right, Mr. Johnson?
Yes, Your Honor. As is known, Mr. Mick, when he's on his medication, he's this phenomenal, easy to talk to guy. He's actually very inquisitive and smart. And then there's these periods of time where the medication lapses or otherwise, and things go off the rails. This is Mr. Mick's first felony offense, and I think there's something to be said for the fact that he was. In my conversations with him, we talk about this. He says I had to go to jail to become a felon, and I think there's something to be said for that. He was in there. He, had disclosed that he was schizophrenic, and there was some documented delay. in the medication, in receiving the proper medication while in the jail. With that being said, I do believe that in a proper structured environment, like with his sister, Mr. Mick can absolutely thrive and succeed beyond today. So for that, Your Honor, I would just ask that those things be considered and that we can get him with his sister as soon as possible.
All right, Mr. Mick, anything you'd like to say? Mr. Mick, anything you want to say? All right. All right, Mr. Mick, I'm going to go ahead and sentence you today to 3 years of community control, or actually I'm going to make that 2 years. 2 years of community control or probation under these terms. You're to obey all laws of all jurisdictions, conduct yourself in law-abiding manner at all times, and you're to report when and as directed. Now, I'm going to allow you to go to be transported to Massachusetts immediately upon availability of your sister or another family member to take you there. So you're going to stay in jail till they can get down here and take you. Once they are here, you can be released to them. You'll have to report. Initially, you'll be up there on a pass. It's going to take a little paperwork and time to transfer your supervision up there, so you may have to report in by phone or by Zoom or something. The probation department can talk to you about that. You will be required to report then once you're transferred to the Massachusetts to the probation department up there when and as directed. You must keep them informed of your residence, place of employment at all times, and may not change either without prior permission. You're not to purchase, possess, own, use, or have under control any weapon of any type, firearm, ammunition, or dangerous ordnance. You're not permitted to purchase, possess, or use, have under control any kind of a controlled substance or drug of abuse or any item or instruments similar to those, or any equipment that may be used to administer them, unless you have a prescription for both, and you'll have to present that to the probation department within 24 hours of receipt. You're to submit to drug testing when and as directed. You're not to consume or have under control any alcoholic beverages. You must report any contact with law enforcement or any information or any arrest, citation, or conviction for an offense not later than the next business day after that occurs. And if you're referred for an evaluation or assessment by your probation officer for any type of treatment, therapy, or counseling beyond that which the court orders, you're to submit to that. If they recommend any kind of programming, you're to enroll in and successfully complete that. You're going to be required to reside with your sister in the state of Massachusetts. So as I said, the probation department will give you a pass for that until you're transferred up there. You must comply with your mental health treatment. So that means you need to take your meds and stay on your meds and go to the doctor when and as directed. And by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, your residence, vehicles owned by you or used by you, or any other property place where you're found at any time, any officer of the probation department. Now, in the event that you fail to pay, you're also to pay the court cost. If you fail to do that, the clerk can collect that through various means, including levy on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion, if that doesn't collect it, then the court could allow you to do community service. They give you credit for each hour you worked and an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. You're also informed that in the event that the probation department does file a notification and you're found to have violated these conditions and are sentenced to a prison term, upon completion of that prison term, the adult parole authority has the authority to put you under post-release control supervision for up to 2 years under the terms they set. And if you fail to comply with those, they could return you to prison to make you serve an additional period of up to half of your prison term for one or more violations. However, if you're convicted of a new felony, then in addition to whatever sentence the judge in the new case would impose upon you, that judge will also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively the sentence in the new case. All right, so as soon as your sister can get here to pick you up, Mr. Mick, you can be released. All right, is there anything further from counsel?
No, Your Honor.
Your Honor, I did just speak with Ms. Sturgill, and she will be out tomorrow to do his paperwork so that they can transfer him. She actually couldn't even file for it until he was sentenced.
Okay.
So she's going to start that right away.
All right. Anything further, Mr. Johnson?
No, Your Honor. Thank you.
All right, thank you. All right, we need Mr. Patel next. All right, this is case number 25 CR 66, State of Ohio versus Yash Kumar Patel. And you're Yash Kumar Patel?
Yes, sir. But before we proceed, may I have a chance to speak something? It's really important.
Well, no, wait a minute. All right, now, this is a pretrial. Mr. Patel is represented by attorney Daniel Witt. This is a Zoom hearing, so Mr. Patel is appearing from the jail. Ms. Witt's appearing from her office. Appearing on behalf of the state is prosecuting attorney Annika Collins. The defendant is charged with theft by deception from a person of protected class, a second-degree felony, and attempted theft from a person of protected class, a fourth-degree felony. This is the first pretrial. Ms. Collins have the alleged victim or victims of the offense. The offense has been notified of the time, place, and purpose of this hearing, the right to be heard.
Yes, Your Honor, and is not going to be attending the hearing.
All right. Now, I see that the state has provided discovery and a bill of particulars. You received that, Ms. Witt?
Yes, I have.
All right. Your discovery is due by the final pretrial. Do you anticipate any pretrial motion?
Not that I'm aware of right now.
All right. Has there been a written plea offer provided yet?
There has.
Is your client aware of it?
Yes, I discussed it with him this morning.
All right. All right. So I believe our next hearing is set for June the 4th at 1 o'clock. Now, Mr. Patel, you had something you wanted to say. Have you discussed this with your attorney?
Yes, sir. This is regarding the same matter
regarding what?
Regarding the same matter that I discussed with my attorney. So I just wanted to let know the court about this matter to bring up to the court that for the specific charge, felony 2, that was dropped on me on 4th of April.
Well, we're not going to discuss it. We're not trying the case here today. I'm not exactly sure what you're talking about.
Yes,
but if you have something you would like to bring to the court's attention, you need to talk to your attorney. She'll file a motion, an appropriate motion, and then we'll discuss it at that time. I'm not going to take up time here just to listen to something that your attorney's not involved in. You can't represent yourself. You have an attorney. You could represent yourself, but if you do, you have to do it all. You can't let your attorney represent you part of the time and you part of the time. That's not how the system works. So you need to say something. Ms. Witt, you need to get in touch with him so you can discuss that with him to see if it's something that needs to be brought before the court.
But they are not really helping me in this case. I want to change.
I'm sorry, what?
They are not helping me in this case.
They're not helping you in the case?
Yes, sir.
Well, the case has just started. It's early. She had to go through the process of getting the discovery and looking at that and evaluated it. So she'll be out to talk with you and discuss the matter with you, and then you can discuss what you think you should do, and then she'll tell you what she thinks about the case, because she's a trained and experienced lawyer, and she'll have them in. And if you don't agree with that, that's fine. You don't have to accept her advice. That's what she's there for, is provide you advice. That's up to you to decide whether you want to follow her or not. You don't have to. She'll be in contact with you. All right. Anything further from counsel?
Not from counsel, Your Honor.
All right.
No, Your Honor.
All right. Thank you. All right. Are you Stephen Allen Jacobs? Are you Stephen Allen Jacobs, appearing there from the jail?
Yes, Your Honor.
All right. This is case number 25-CR77, State of Ohio versus Stephen Allen Jacobs. Mr. Jacobs appearing by Zoom from the jail. His attorney is Jacob Wagner, appearing from his office. Appearing on behalf of the state is is Prosecuting Attorney Collins. The defendant is charged with trafficking in drugs, possession of drugs, 2 counts of aggravated trafficking of meth, and 2 counts of aggravated possession of meth. I believe this is a first pretrial. Final pretrial will be on June 4. Trial set for the 26th of June. Let's see. Oh, here it is. The state has provided discovery. You've received that, Mr. Wagner?
I have, sir. Excuse me about that, Your Honor. Yes, I have.
All right. Your discovery will be due by the final pretrial. Do you anticipate any pretrial motions?
Not at this time, sir.
All right. Have you received a written plea offer?
I have, sir.
Is your client aware of it?
I don't think so. I got it after I'd been out to see him, Your Honor. So I didn't get back out tomorrow or Friday.
All right. Any other matters to be discussed then at this time?
No, sir.
All right. Thank you.
Thanks, sir.
All right. That's the last one in jail?
Yes, Your Honor.
All right. What's your name there at the probation department? Case number 25-CR54, State of Ohio versus Donald L. Holt. Mr. Holt's appearing from the probation department. His attorney is Daniel Witt, appearing from her office. Appearing on behalf of the state is Prosecutor Collins. This hearing will be a Zoom hearing on a pretrial. Mr. Holt is indicted for aggravated possession of methamphetamine and tampering with evidence. This is the first pretrial, or final pretrial. Trial is set for June 23. All right. I don't see any compliance with discovery from the defense. Ms. Witt?
No, not yet, Your Honor.
All right. Well, it was due by today, so I'll give you till Friday to get that in. And there's no pretrial motions?
Judge, this isn't the final pretrial.
All right. Maybe I misread. I must have misread that then. I'm sorry. Oh, I'm sorry. This is first pretrial. Final pretrial set for June 4 and trial set for June 23. All right. All right, so the discovery will be due by the final pretrial, and you're anticipating pretrial motions? You said no?
No, not at this time.
Has there been a written plea offer provided?
There has been.
Is your client aware of it?
Not yet. If he could actually come over right after this pretrial, I have time to see him.
I will.
All right. You know where her office is, Mr. Holt?
Yeah, I was over there earlier.
All
She
right.
wasn't here.
All right. Well, then, as soon as you leave the probation department, you can walk right on over there.
Okay.
So we'll see you then on your final pretrial on June 4.
Okay.
All right. Anything further, counsel?
No, Your Honor. Thank you.
All right. Thank you. All right. Then, McMurray. Case number 25-CR57, State of Ohio versus Scott McMurray. This is a pretrial. Mr. McMurray is charged with aggravated possession of methamphetamine. He is not present. His attorney is Sarah Barger, appearing by Zoom from the prosecutor's office is Prosecutor Collins. This matter is set for final pretrial on June 4 and a trial date on June the 26th. Now, we've been receiving communications here, court staff has, that I see now there is an email from the Recovery Council. Apparently, Mr. McMurray has been in a hospital in Adena, Chillicothe, for mental health issues, and is scheduled to be transported to TRC on May the 27th. So he has the probation department's been in touch, and so he is not present. So we'll go ahead and just continue this matter of progress, and if you can reach out to him at the counseling center, Ms. Barger, then that way we'll hopefully be able to get the matters finished on June the 4th. Any other matters be discussed at this time?
No, Your Honor.
No, Your Honor.
All right. Thank you. That's it then? All right.